A Nairobi woman has been charged by a Nairobi court with obtaining goods worth 19 million shillings through false pretense.
Halima, who runs a non-governmental organization, denied the charges and was released on a bail of 500,000 shillings and a bond of 200,000 shillings.
The case is set for hearing on the 4th of December.
Heard that Halima had on diverse days attempted to fraudulently obtain goods contrary to Section 313 of the Penal Code and conspiracy to commit a felony contrary to Section 393 of the Penal Code. This was through a stretch of diverse dates between 13th February and 20th March this year.
The intended accused person to a bond of Kenya shillings 500,000 with a surety of a similar amount, and then alternatively a cash bill of 200,000. with 2 contact persons. So the matter will be mentioned before court number 5 for further directions and orders.
The prosecution opposed the release of the accused on bail, citing prior offences equating to the current charges. The defence argued that due to time constraints, they were not able to file a formal application.
What the defence counsel sought was time to file a formal application seeking time constraint. The application has been vivaciously opposed by the prosecuting counsel, Ms. Kariuki. She urged that nothing bars the court from proceeding with plea taking. No grounds had been adduced. She submitted that by dint of Section 193A of the Criminal Procedure Code, both criminal and civil procedure can proceed contemporaneously.
Senior Principal Magistrate Ben Mark Ikubi granted the prosecution time to apply, though he stated that the accused had attended prior hearings and posted bail.
I'm of the considered view that the intended accused person ought to be granted time to file a formal application to be determined on merit. I find that preliminarily the defense counsel have raised substantive issue on the defectiveness of the charge sheet.
Letua Deborah for Prime Edition.